let's understand what are the important questions that your privacy notice should answer, and it should answer in a way which is not too hard to read, right? Um, who collects the person data and who will further process the person data, right? So this portion should basically include the following information. How have you collected my data? Basically, the sources of data collected, whether you have collected directly when I signed up on your particular platform, whether have you collected it through a marketing campaign that you ran on Instagram where I swiped up and just checked out your product, or maybe signed up through there. Whatever the source is of data, it needs to be present there. And for that, you won't be sitting in a vacuum to do it. You should engage as many personnel as you can, ideally confirming that the entity is collecting the data for specific reason, right? You need to confirm whether the entity is, collecting the data firstly and for what specific reason. Now we're going to look at a privacy notice and this all will get clear. Now, what are the other third parties with whom your information will be shared? So what personal data are you collecting, right? Now, since the sources are different, there would be multiple data sets that you would be collecting as as a company, right, or as a business. So this should ideally include the information that is directly provided by the users, basically through signups, login, whatever, through their devices as well, right? Information that is artificially collected, that's also device information. Device information in particular head is also mentioned because a lot of times, if let's just with the AR VR technology, then device information would be a list of its own, right? Incredible list of its own. It would engage us. It would engage all the functional necessities of your device. Information when someone actually uses the services of the data controller, right? So all of that we mentioned. Then comes the next question: how will the personal data be processed? Now, here is something. This is an interesting exercise you can perform for yourself. This is where most of the companies they would have a very generic statement. There are exceptions, of course. You can go read BBC's policy. You can go read OnePlus policy, privacy policy. They would have specific takes on how they are using your personal data, but usually it would be a generic take that will provide services. We will be giving you recommended services. We will be giving you improved services, right? Go read maybe Meta's policy. It's not really that clear, right? And this is where your role as a lawyer or a professional kicks in, right? You basically ensure that the regulator does not come knocking at your door with a great, likelihood. I'm basically saying that your privacy policy or a cookie policy is just, is just not that conspicuous and clear, right? So this is what you basically mentioned. You mentioned that, we provide you these and these services. You make another table. You mention all the services that you give. You respond to data subject requests and complaints. This is also a reason for them processing your data, right? For further improvement and personalization of the services, recommendations, research, and emailing activities. Then there is marketing profile analyzing of user data. This is strictly on your consent basis. Okay, so this is the third question that your privacy notice should be answering, right? Now, what are my rights and how do I exercise and access my rights? Two very important things. Two that on their own. So your rights are basically which are there. We have already talked about, right, at length. So those rights, right to deletion, right to restriction, right to right to be forgot. All of these rights, right? 7 to 8 rights. You mentioned clearly, right? And then you mention or create maybe a Google Doc form, whatever is more interactive as per your company, where you go and basically say that you click on this link for you to access these rights. Then you can open inform forms where you ask them to fill right to access form or to deletion form, right? All of that. So that is separated altogether. So these two things definitely should be there. Like I said, specific link to exercise each right should be mentioned in your policy. So yeah. Then comes, is the business entity taking enough steps and measures to ensure the safety and protection of data? So here, depending on the industry that you work in, let's just say if you're working in the banking industry, then absolutely it should be there, right? Because not just the GDPR would kick in, your sectoral regulator or your central bank or whoever is the regulator in that space, they would definitely want you to mention this in all your user terms, right? So the privacy policy should certainly reflect that. So the privacy policy reflects the privacy by design and default measures taken by the controller in an understandable manner. It's encryption and pseudonymization. It could be ISO standards, which are certainly cybersecurity standards, which are considered equivalent of being compliant with GDPR in a certain way. Logging all activities of the data subject, ensuring safety of data when processed or transferred. Now, transferred, I mean even if it's transferred to another country, whether it's adequate or not. Yeah, right? So, yeah, this is the fifth question. What are the steps are you taking, right? Now, next is, when will the personal data which is being expired or and be deleted by the business entity? Regardless of the data being collected directly or indirectly, the privacy policy should mention the time period of storage of data or the basis on which the time period will be assessed, right? I'm going to show you an internal privacy notice. There you will be able to figure this out much better, right? So think of these questions as like a framework on which you will be drafting the privacy notices on the basis of what the notices that I will show you, right? The next question is, does the business entity appropriately inform and notify the users when there are changes made to the privacy policy? Now, if you go look in GDPR signs, they would find some where minor infraction or minor fine has been issued by certain regulators on the fact that appropriate notices were not issued to data subjects on modifications to the privacy policy, right? So you have to avoid that. You have to bring in that, right? So simply updating the data notification is not enough. Reasonable steps need to be taken from the data subjects with the help of email notifications or in-platform notifications explaining the relevant changes, right? Now, big companies, of course, have a much more degree fine to pay. So companies like Facebook, Twitter, and significant social media intermediaries like them, like our platform, they inform their users sending an email, and they would also display it whenever you would log into Instagram that we have changed our privacy policy or we would change our cookie policy, right? And the same goes for Facebook and Twitter as well. So these are the great practices, and you should definitely suggest it to your company, which or your client, whoever you're working. The next question is, whom does the data subject contact in case of a grievance? So under the GDPR, like I said, you have to appoint a DPO in two specific circumstances. The first one is obviously when you are processing data on a large scale, and secondly, whenever you're basically collecting personal data on when you're collecting a lot of fields of data, right? So basically, then you have to basically enter DPO, right? And these things have been further clarified by the European Data Protection Board. But nonetheless, you have to have a DPO and its contact information in summary, right? So the privacy policy should mention the contact details of the designated personnel, which is the TPO, which has been appointed by the intermediary. A lot of times you would basically understand that data privacy consultancies or the Big Four or wherever privacy is a separate department, they basically externally get hired by organizations to act as DPOs. That is the case a lot of times because of the sensitive nature of the job. Because if you're not adapt at understanding what would be the ramifications of a small response to a data subject access request form, then there would be trouble, right? So a lot of times DPOs are currently hired as well. Okay, just a small information.